Good afternoon and welcome to the Abigail Adams Institute annual lecture. My name is Danilo Petranovic. I work here. I'm the director of the Institute, and I would briefly like to introduce us before I introduce today's topic and the speaker. Abigail Adams Institute is an independent scholarly institute located in the Cambridge intellectual community. We're Harvard adjacent, as some people say. We provide supplementary humanistic education, above all, to the Harvard intellectual community, and that's supplementary and humanistic broadly understood, which means programming in philosophy, political science, literature, history, and many other things, depending on our student and faculty and young alumni interest. At the end of this event, around 5:25 or so, I will pause and preview a few of the live events that we have coming up. We prefer to have live events, but today here we are back to Zoom. And however, that worked out great for us today. As those of you who are in Cambridge know, we have a pretty sizable snow today, so we probably would have would have been doing this anyway. Okay, today we're delighted to welcome Dr. Piereson. I will introduce him shortly to the annual lecture. Before that, I want to say that each year we invite a speaker to be our main speaker for the year. And while we prefer smaller events, seminar-sized events, reading groups, now we have popular Shakespeare group and film series, we do want to feature big speakers and big topics. The point of these lectures is to bring the community together. Now we do it remotely, of course, and also to challenge us. We want a big topic, and we want a challenging topic that helps us rethink and reimagine cultural possibilities in the modern West. So in the past, I think our inaugural kickoff speaker 6 years ago was Richard Legutko, a famous Polish philosopher, wrote this book, Demon and Democracy. That was challenging and interesting. We had Peter Berkowitz, Professor Berkowitz speak. We had Daniel Mahoney. We had our own Erica Bakioki, and so on and so forth. So this afternoon's subject is the Voting Rights Act, 6 decades later. It's a good classic political science subject, and I hope you will enjoy it. Our speaker this afternoon is really my pleasure to introduce Dr. James Piereson, who is a Manhattan Institute Fellow and President and Trustee of the William E. Simon Foundation. Previously, he served in political science faculties of Iowa State University, Indiana University, and the University of Pennsylvania, where he taught government and political thought. He sits on numerous boards. I won't name those, and foundations, but I do want to highlight some of his scholarly output. He's the author of Camelot and the Cultural Revolution: How the Assassination of JFK Shattered American Liberalism, 2007, The Inequality Hoax, 2014, and I believe 2016. I have it right here because he gave a talk about this book here at the Institute 6 years ago, Shattered Consensus. Most recently, he wrote a little booklet or broadside with Encounter Press on the growth deficit. I really want to focus more on this book, some other time. So, okay, Dr. Piereson also co-edited numerous books, and his work frequently appears in the New Criterion, Commentary, National Interest, Public Interest, Wall Street Journal, and so on and so forth. Dr. Piereson holds a BA and a PhD in political science from Michigan State University. Okay, now, Dr. Piereson, welcome back to the Abigail Adams Institute, and please take it away.
Thank you very much, Danilo. Delighted to be back with the Abigail Adams Institute. I wish I could be there in person. I have been there in person 3 or 4 times in the past, and I hope to come back again maybe next year if Danilo will invite me. Our topic today is the Voting Rights Act after 6 decades. We're talking about an act, the Voting Rights Act, that was passed by Congress, signed by President Johnson in 1965, and has been elaborated and has been a point of controversy over these many decades. So let me go through this. It's a big topic, and I think a very interesting one. Start here. This is the 15th Amendment to the Constitution, ratified in 1870. It's one of the post-Civil War amendments. It's very brief. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. So the point there is to make sure that these freedmen from the Civil War are able to vote. And almost all of them, 90+%, live in the states of the former Confederacy. Now, this Section 1 of the 15th Amendment is pretty much reproduced, almost word for word, in the Voting Rights Act of 1965. Okay, so this is a number of Black legislators in the South from 1868 to 1900. And as you see, there are a large number of them in the early years of the post-Civil War era. Here, we're talking about the period from 1868 into the 1870s. And now we're into the late 1870s and down to 1900, there are none. I couldn't find a good summary of the votes, but the number of legislators in the South is a good proxy for voting. So you have a lot of voting in the early years of Reconstruction. It declines through the 1870s and disappears by basically 1896. So what happened? You passed the 15th Amendment, you fought a Civil War, Blacks are voting in the South, and by the 1890s, it's gone. What has happened? So the first post-Civil War amendment was the 13th Amendment banning slavery. So Section 1 basically banned slavery across the United States. That's what the Civil War was fought for. That drawing on the left is a celebration when the Congress passes it on February 1, 1865. Lincoln is still alive at this time, and he shepherds it through the Congress. It now has to go to the states, where it will be ratified by 3/4 of the states. And that is done by the end of 1865, by which point Lincoln is no longer living. So there are different approaches to Reconstruction. Lincoln, of course, dies in April of 1865, and he and his vice president, Johnson, who becomes president, had a fairly modest approach to Reconstruction. One question was it all about slavery? We passed the 13th Amendment, and that's what the Civil War was all about. And so when slavery is now gone, the southern states, former Confederate states, can now come back into the Union if they swear allegiance to the Constitution and to the Union. So both Lincoln and Johnson were going to give pardons to all of the Confederates, except maybe the top leaders and officers, once they gave an oath to the Constitution, and required states to eliminate slavery, ratify the 13th Amendment, and allow the Blacks to participate. Andrew Johnson forced the leaders of the Confederacy to come to Washington and sign a petition saying that they upheld the Constitution. And he required ratification of the 13th Amendment. Now, in 1865 and 1866, when Congress assembled, the Republicans looked around and saw that the southern states had sent many members of the former Confederacy into the Congress, including former members of Congress who had sworn an oath to the Constitution, but then joined the Confederacy. And so those Republicans who constituted a majority in the US Congress at the end of 1865 said, we are not going to seat the Southerners who've been sent to the Congress because we want to remake the South much more radically than either Lincoln or Johnson proposed to do. And so they required 50% of the state's voters to take an oath of loyalty. They divided the South into military districts. Remember, the Union Army was still occupying the South, and they stayed there. And they required the legislatures to adopt new constitutions guaranteeing African American suffrage. And many of those African Americans voted and participated in these constitutions that took place between 1866 and 1868. And it required states to ratify the 14th Amendment, I'll come to that in a minute, in order to seat representatives in Congress. There's some question as to whether or not this was a legitimate way to get the 14th Amendment ratified. In other words, states had to ratify it before they can come back into the Union. So these are the 5 military districts across the South. And, some of the prominent Union generals, Sheridan, Grant, and others, kind of stayed in the South to implement Reconstruction, and mostly to make sure that those freedmen are now able to vote. And this is the 14th Amendment. I have abridged this. This was approved by the states in 1868. It really codifies the Civil Rights Act of 1866 and puts it into the Constitution. But, it basically says that the freedmen in the South are citizens of the United States, because the Dred Scott decision in 1858 said that they were not citizens, that could not be made citizens. So the 14th Amendment makes them citizens and says that states cannot deprive anyone of life, liberty, property without due process of law and the equal protection of the laws. And it also says there in Section 2 that states that deny the right to vote will lose their representation in proportion to the extent that suffrage is denied. So the 14th Amendment codifies the Civil Rights Act, grants citizenship to the recently freed slaves, guarantees the right to vote, and the Southern states are required to approve this amendment as a condition for reentering the Union, and all do so by 1870. So one of the things that happens here is that the Southern states are basically out of the Union in these 2 or 3 years after the Civil War until about 1868 or 1869. And white people in the South boycott the early elections, which allows blacks to vote and dominate the legislatures in some of these states. So more than 600,000 black men, remember suffrage is restricted to males at this time, vote across the South in these years. 16 blacks served in Congress. Mississippi elected 2 black members to the U.S. Senate. The Mississippi legislature was a majority black through several years in this period. There were efforts by whites, all Democrats, to exercise violence to keep freedmen from voting. And the Ku Klux Klan is organized at this time to launch a reign of terror across the South to prevent blacks from voting. And the Congress passed several acts through this period to prevent this from happening. In 1870, Congress passed an act to outlaw disguises and masks to protect the rights of citizens. And there was a Ku Klux Klan Act in 1871 to protect freedmen to vote. So all these are issues that come up in Reconstruction that would come up again in the 1960s. So what happens? Well, one of the things that happens is that as the whites begin to vote across the South and the Southern states return to the Union, the Democrats take control of Southern states. So the white voters all vote for Democrats, and in the South, blacks are voting for Republicans. Now, the idea that the Republicans had was, we are going to create a 2-party system across the South. White voters, most of them may vote for Democrats, but the black voters will be a base for the Republican Party. And we'll pick up some white voters also. So we'll have 2-party competition across the South, and that will be a means by which we remake the South and guarantee full citizenship to those newly freed slaves. So it becomes difficult now because of the Depression of 1873, Democrats capture the Congress. And what that means is that they remove the radical Republicans who control the House, and they now are going to vote to limit, maybe end Reconstruction. This is the election of 1876, the presidential election. So the Democrat Tilden from New York wins the popular vote. He has 184 electoral votes. The Republican Hayes is from Ohio. Tilden is from New York. Tilden is governor of New York. Hayes is governor of Ohio. There are 20 disputed electoral votes. So as you can see, if you take Hayes's electoral vote and add those 20, he wins the presidency 185 to 184. The contested votes are in Florida, Louisiana, and South Carolina, plus one in Oregon. And by contested, it means that rival delegations of electoral votes or slates have presented themselves to the Congress, and Congress can't sort it out. So they appoint a commission, which of 9 people, 5 Republicans and 4 Democrats, and they vote to give all those electoral votes to Hayes. Hayes wins the presidency. But Democrats force Hayes, as a condition of this, to withdraw all troops from the South and end Reconstruction. So these 2 elections, 1874 and 1876, basically force withdrawal of troops from the South and bring an end to Reconstruction. So that is the reason why the Black voting in the South plummets, because now the Democratic Party controls the South. They exercise a reign of terror on Black voters, and they now begin to pass all sorts of artifices to keep Blacks from voting. Literacy tests was the main one. So, in order to pass a literacy test in the South, if you were a would-be Black voter, you probably had to be either a great mathematician or a great historian. But basically, you weren't going to pass the literacy test. They also had grandfather clauses. And the grandfather clauses said that if your grandfather could vote in 1860, you didn't have to pass a literacy test. Well, we know who voted and did not vote in 1860. They also approved poll taxes. So basically, by the 1890s, Blacks were effectively disfranchised across the South, because the 15th Amendment said you couldn't ban voting on the basis of race or color, but you could have literacy tests and you could find a way to ban them through literacy tests. Now that wasn't fair, but a lot of northern states had literacy tests too. And as immigrants came into the country, they made those immigrants pass those literacy tests. So the Republicans in the North had to somewhat accede to this across the South. One other thing happened in the 1880s and 1890s. Several northern states, Michigan, Pennsylvania, New York, flipped to the Republican Party. So Republicans began to see that we can win the presidency without having to carry any states in the South. And so that led to the one-party South that persisted really into the 1960s. One other thing that happens is that beginning in the early part of the century, Blacks begin to leave the South and move to the North. So as this happens, beginning about 1910 or 1920, running into 1970 or so, the proportion of Blacks in the southern states decline, so that Blacks, even if they voted, could not dominate those states in the way they might have done in the late 19th century. You can see those numbers that begins to level out after 1970. One other thing happens that as Blacks move north, they begin to exercise some influence over northern congressmen and presidents. And they begin to put pressure on the South to begin to change its ways, beginning in the 1940s, 50s, and 60s. So that is an example of federalism working kind of on behalf of putting pressure on the South in the modern period. Of course, now we have also beginning in the 1950s a very liberal Supreme Court, an inheritance from the Roosevelt appointments to the court in the 1930s and 40s. The liberal bloc is Earl Warren, the Chief Justice, Douglas, Black, and Brennan. This is Warren, this is Douglas, this is Black, and this is Brennan. And that's a very formidable conservative bloc that's in place in the 50s and 1960s. And they begin to approve very liberal decisions. They order the desegregation of Southern schools. They ban prayer in the public schools. They change the libel laws, which make it very difficult to prove libel. They outlaw contraception in 1965. Very importantly, they passed a decision in the early 1960s forcing states to reapportion their state legislatures. Many states had legislatures that had not been reapportioned after censuses in 30 years. So the districts in the states and in the Congress had radically different populations. You might have a congressional district with a few thousand voters and another district in the same state with many hundreds of thousands of voters. That was true of state legislative districts as well. And so the Supreme Court came in and said, that represents a kind of vote dilution. And so they said that districts have to be, as far as possible, equal in population. And they also had to be more or less compact and contiguous on the map. So here they introduced the idea of vote dilution. If there's not an equality of votes, some voters have had their votes diluted, and this violates the Equal Protection Clause of the 14th Amendment. Now, up until this time, some jurists have said that the court should not enter this political thicket of especially districting, but the court jumped into it anyway. And that was one of the profoundly influential decisions that they made, because they forced all these states to redraw their district lines so that all these districts are equal in the legislature and in the Congress. So they've called the 1960s the Second Reconstruction because of the Brown decision, the desegregation decision in 1954. Blacks began to march and demonstrate across the South demanding equal rights. This led Southern whites to overreact in significant ways. We see here a case of a dog attacking a demonstrator. There were assassinations across the South, clubbings, beatings, and this turned Northern opinion against the South and led to the passage of these civil rights laws that we'll get to in a minute in the 1960s. Because of this situation right here, this takes place in Birmingham, Alabama in May of 1963. As a consequence of these photos going on the news and films going on the news, President Kennedy proposed a new Civil Rights Act in 1963 that very much mirrors the Civil Rights Acts that were passed during Reconstruction. This is Martin Luther King speaking at a huge demonstration in Washington in the fall of 1963, not exactly the fall, August of 1963, at the Lincoln Memorial. And this is where he gave that famous "I Have a Dream" speech about everyone in America being equal and judged by the content of their character. Within a few months of this happening, John F. Kennedy is killed. Lyndon Johnson becomes the president. And Johnson, on racial issues, is much more liberal and progressive than Kennedy. And he wants to go much further than Kennedy in pushing civil rights laws. And One important difference between this period and the Reconstruction period is that Johnson in 1965 will pass a raft of social welfare programs in support of education, eliminating poverty, supporting health care for the aged, and supporting health care for the poor. This was not true in Reconstruction. And this is also a very important aspect of this period. So this is the Civil Rights Act of 1964, passed mostly by Northern opinion, Republicans and Democrats in the North getting together to pass this bill. It prohibits discrimination on the basis of race in public accommodations. And they used the Commerce Clause as the basis for doing this. Title IV prohibits discrimination on the basis of race in educational institutions. And Title VI is very important, turns out, because it prohibits discrimination in programs and institutions receiving federal funds. Now, this was not so important in 1964 because there weren't a lot of programs. But once the Congress passes Medicare, for example, in 1965, and Medicaid in 1965, and the Higher Education Acts in 1965, now all these Southern institutions cannot get federal funds unless they desegregate. And so they gradually begin to desegregate in the mid-1960s as a condition of getting federal funds. So Title VI of the Civil Rights Act becomes very important. So this is a presidential election in 1964. Very importantly, the Republican candidate for president in 1964, Barry Goldwater, voted against the Civil Rights Act. And as a consequence of that, the Southern states voted Republican. Remember, these Southern states are all Democratic from this period from Reconstruction all the way down through the 1950s and 1960s, and they now begin to flip to the Republican side. One of the reasons that the South went to war against Reconstruction is not only that they did not want blacks to vote, but they were going to vote for the Republican Party. And the Republican Party was the party that enforced the Civil War. So this was like an enemy political party to the South in that entire period. So now, as a result of the Civil Rights Act, the Southern states begin to flip and begin to go toward the Republican side. Did voters ratify the Civil Rights Act by this election? I think you could say it did. Johnson wins a gigantic popular vote. He sweeps the Senate, sweeps the House, now has these very large majorities, and the Republican candidate has voted against the Civil Rights Act. So this paves the way for the Voting Rights Act of 1965, which moves through the Congress. So Section 2, as you see there, is basically a restatement of the 15th Amendment. Section 4 says that in jurisdictions where 50% of persons of voting age, fewer than 50%, were registered to vote in 1964, and those states have had discriminatory tests or devices to keep them from registering, those mostly literacy tests, those states had to petition the Justice Department or the District Court of the District of Columbia before they made any change in their voting laws. And basically this applied to the Old South. So any changes in their voting laws had to get the approval of the Justice Department, basically. Section 4 defined the conditions for pre-clearance. This is what it was called, pre-clearance. And Section 5 forced them to go to the Justice Department or the District Court in the District of Columbia. Again, this act was passed overwhelmingly in the Senate and in the House. Southerners voting against it. So these states here, the southern states, plus some districts in North Carolina and Virginia, and a few in some other places, were the states that had to get pre-clearance from the Justice Department before making any changes in their voting laws. One thing I should say here is that the Voting Rights Act, given the term, applied to voting, did not apply to anything else. Conditions for voting, basically registration and going to the ballot box. Now, these other states I've got here, Texas, Arizona, Alaska, some counties in California, some counties in other parts of the country, these were added later as jurisdictions that required pre-clearance. Okay, Lyndon Johnson signs the Civil Rights or the Voting Rights Act on August 6th, 1965, like the week before it had passed the Senate and the House. And right at this point, the Justice Department sends officials to the South to begin registering voters under the Voting Rights Act. And again, this is a little bit like Reconstruction, where voting rights were protected by Union soldiers. Within a week, race riots break out in Los Angeles. And this is a precursor to racial riots that happened in northern cities throughout the 1960s. They were all started in more or less the same way. There's an altercation between white police and some black citizen. Violence ensues. It escalates into wholesale race riots, burning of the city, dozens of people killed. This becomes a kind of a model for what happens in many cities across the North. So the Voting Rights Act targeted the South, but it appears now, because of this migration we spoke about, that the racial conflicts have moved to northern cities. And the whole voting issue doesn't really apply to the northern cities because no one is kept from voting. And the conditions in these northern cities are far different from what has taken place in the South. So it creates a new kind of controversy and crisis and challenge for the country as this occurs. So the impact of the Voting Rights Act is pretty significant immediately. On the left, we have the percentage of voters, whites and blacks, registered in 1965, and the number of registered 2 years later. So in every state across the South, it's well below 50% in 1965. Some states like Mississippi is extremely low. And now more than 50% of voters are registered in all the southern states within a 2-year period. And this will continue. This is the number of state legislators in southern states. The red line is the Reconstruction, and the blue line is the number of legislators in the South in the 1960s and moving forward. So you can see that there's a radical change beginning in 1964 and continuing all the way through into the 1990s. So the Voting Rights Act has a big effect on voting across the South. This is voter turnout in presidential elections, 1952 to 2012. This thick black line is black voting. Very small number of blacks vote. This is in the South, so hardly any vote in 1952. 1964, you see a significant increase. And by, the early 2000s, black voting in the South looks pretty much like white turnout. This is white turnout in the North. This is white turnout in the South. So all these groups look pretty similar by 2004, 2008, mostly because of the Voting Rights Act, Civil Rights Act as well. This is Black Party identification. And here's the Civil Rights Act here. So blacks are moving into the Democratic Party pretty heavily through the 1950s. The Civil Rights Act pretty much solidifies it. So I think this is in the South. So you get blacks moving into the Democratic Party, and you also now get whites moving into the Republican Party across the South. This is a share of whites identifying as Democrats in the South. In 1950, 78% of whites said they were Democrats. You see that decline pretty steadily through the decades. By 2004, it's 22%. Today, it's around 15%. So now you have a situation where 95% of black voters support Democrats, 80% of white voters support Republicans. And so there's a fair amount of racial polarization across the South. This is Republican House and Senate seats in the Deep South, 1952 to 2016. The heavy line is the percent of Senate seats. There are a few Southern senators in Texas and Maryland in the 1950s and 1960s. But by the time you get into the modern period, most of the House and Senate seats in the Deep South are held by Republicans. That is a tremendous realignment as to where things stood in 1950. So now we talk about the expansion of the Voting Rights Act. So I was saying that the Voting Rights Act applies to voting. So in this case, Allen versus the State Board of Elections, that's decided by the Supreme Court in 1969, it raises a new question. And the states of Mississippi and Virginia changed their election laws after the Voting Rights Act is passed. So county supervisors in these states are now chosen in at-large elections. And county superintendents of education are now appointed rather than elected. Now, it was said that this was done to circumvent the Voting Rights Act, because if you take jurisdictions which might be 30% or 40% black, and you elect all the supervisors in at-large elections, the same 60% majority can elect all of the counselors or supervisors or legislators by the same 60-40 margin. Whereas if you had voting by districts, they could elect 40% of the legislators or supervisors. And the county superintendents of education, once elected, the voters might have elected black supervisors or superintendents, but now the idea is they will be appointed and there will be whites. So black voters in these two states sued in federal district court, and they claimed that these districting decisions violated the Voting Rights Act because it was designed to circumvent black voters, according to the Voting Rights Act, and their votes were diluted. So now the states said, wait a second, this does not have to do with voting. Everybody can vote. This has nothing to do with registration or going to the ballot box. Everybody can vote. It's not covered by the Voting Rights Act. However, the Supreme Court said that the Voting Rights Act now covers issues like districting, drawing of district lines, the kind of districts you create, whether they be multi-member districts or single-member districts, especially if these are designed to keep blacks in a minority. So we're not stopping blacks from voting, but they're keeping them from exercising their voting power. So this is a significant expansion of the Voting Rights Act because it now allows individuals to sue under the Voting Rights Act, and it applies the Voting Rights Act to election rules that go well beyond voting. In 1975, Congress expands it further. Should other groups be covered under the Voting Rights Act? So the 1975 amendments to the Voting Rights Act prohibit state and local governments from enacting any voting procedure designed to deny or abridge the right to vote citizens because he or she is a member of a language minority group. What's a language minority group? Well, that includes Asian Americans, American Indians, Alaskan Natives, or persons of Spanish heritage. And it requires that in some districts, ballots be printed on a bilingual basis so everyone can read them. And it expands the number of covered jurisdictions to areas where large numbers of Hispanics can vote. And that means Texas is covered, and Arizona is covered, and some districts in California are covered, and some districts in some other states are covered by the pre-clearance provisions of sections 4 and 5. In other words, before they can make any changes in their voting rules, they have to go to the Justice Department for approval. So that is a further expansion of the Voting Rights Act to cover more voters and more states under the pre-clearance provisions. So these are now the jurisdictions that have to get pre-clearance. It even includes some districts in the state of New Hampshire. I think these are Indian reservations in South Dakota. These are areas of California where a large number of Hispanics. The state of Texas is now covered. The state of Alaska is now covered, and Arizona is covered. So I think the idea here is that the Voting Rights Act is now expanded beyond its original boundaries. In the city of Mobile versus Bolden in 1979, the Supreme Court says that if you want to sue and challenge an electoral rule under sections 4 and 5 of the Voting Rights Act, you have to prove that there was intentional discrimination. The effects of the system do not matter. You have to prove the motive was designed to keep Blacks from voting or exercising political power. Now the court has changed. Earl Warren is gone. Richard Nixon has appointed several members to the court, and it's not the liberal court that existed in the 1960s. So these are the 1982 amendments, and one of the things that they changed was they added a results test. And in looking at changes in electoral district, courts can look at whether or not the results of the changes influence minority voting in addition to the intent. The Congress also rejected proportional representation. It said groups are not entitled to representation in legislatures or Congress in proportion to their numbers in the population. It also said minority groups must have a right to participate equally in the political process and to elect candidates of their choice. So one of the things that is happening here is that we have moved from voting rights, which would be the inputs to elections, and we're moving to the outputs of elections where we're kind of guaranteeing or trying to guarantee election results to racial groups. And this is a significant change, which is a great challenge for the courts to administer. And it's also a major change to, traditional American approaches, because in America, individuals have rights. Groups don't have rights. Under John Locke and the Constitution, individuals have rights, but not groups. But now we're beginning to assign electoral rights to groups. Now the US Supreme Court tries to interpret these changes that have taken place, partly because of the amendments of 1982. So they reviewed North Carolina's legislative maps. Go back just for a second. And they set forth a few tests for vote dilution. And one of them is that if a racial group or a language minority group is large enough and compact enough to create a majority in a single member district, and the minority group is cohesive, that is, they vote similarly, and a majority votes cohesively against them, the courts and the legislature should create such a district. So obviously we do have politically cohesive groups in the North and in the South anyway, between whites and blacks voting for different parties. And if you can find a group that's cohesive enough to create a single member district, you're obliged under the Voting Rights Act to create it. So North Carolina's legislature now creates these districts to abide by the Voting Rights Act. And these are pretty strange looking districts. They're not compact at all or geographically cohesive. They're drawn to make sure districts 1 and 12 here have black majorities. Someone made it, there's a highway that goes through here from, I think it's from Charlotte up to the northern part of the state. And if somebody drove up the highway with both doors open, he would hit every voter in the district. So this is an attempt for North Carolina to comply with the Gingell's decisions, or the Gingell's rules by the Supreme Court. But the court struck that down. The court said you can't use race as the only criterion. You can use it as a factor, but not the only criterion. So in Miller versus Johnson in 1995, the Supreme Court strikes this district down because it was a racial gerrymander, but it also makes no geographical sense. So the court is now saying you can't use race as the only factor. You can use it as a factor, but not the only factor. And you can't have wildly constructed districts that make no geographical sense. So now finally in Shelby County versus Shelby County, Alabama versus Holder, 2013, Holder is the Attorney General. The Supreme Court throws out Section 4 of the Voting Rights Act because the requirements are out of date. And the requirements said that if 50% or fewer are registered to vote as of 1964, changed to 1968, you have to get pre-clearance. The Supreme Court says those are now out of date. Blacks are voting widely in the South. It makes no sense. You're treating the states in the South differently than you treat states in the rest of the country. That violates federalism and the equal protection aspect of the 14th Amendment. So they threw out the pre-clearance provisions of Section 4. So that means states don't have to go to the Attorney General to get pre-clearance, and all lawsuits under the Voting Rights Act have to be brought under Section 2, which is a version of the 15th Amendment. And it was a 5-4 decision, 5 conservatives versus the 4 liberals. You see it right here. Very controversial. That is still in place. So Section 4 and 5 of the Voting Rights Act is now out. Congress could pass it again, but they can't muster a majority to do it. This is the chart that Justice Roberts used in his majority opinion. He showed that in 1965 in all these states, there's a great disparity between white and black registration. You can see it on the left, but by 2004, there was no disparity. Blacks were voting and registering at the same rate as whites. So he said that means that the Voting Rights Act has served its purpose and the pre-clearance requirements are now out of date. So there are 2 further decisions by the Supreme Court. In Cooper versus Harris, the court did strike down North Carolina's congressional maps. But one of the things that Justice Alito says is down here, he says, if 90% of African-American voters cast their ballots for the Democrat, a plan that packs Democratic voters into one district will look like a plan that packs African-American voters. So how can you distinguish between a racial gerrymander and a partisan gerrymander? When 90% of Blacks vote for one party, this becomes difficult to do. In Rucho versus Common Cause, another North Carolina decision, the court now said, we cannot decide racial gerrymandering cases. So if a state decides to draw its district lines to protect one or the other parties, and race is not involved, we can't review it. This is non-justiciable, they said, because we have no fair basis by which to decide this. What is a fair map? We have to leave it to the parties to decide in the legislature what they're going to do. So basically, the court has said, we're not going to decide partisan gerrymandering cases. We will decide a racial gerrymandering case, but only if race is used as the main criterion to draw these districts. So things are getting very confused by this point at the Supreme Court. And this brings us to the case of Merrill versus Milligan, the case that's now being decided by the court. It was argued in October. It will be decided at the end of the year. So Alabama drew new districts after the 2020 census, and the district looks very much like the old district that was used prior to 2020. But a group of Black voters sued and said that it's possible to draw a second district with a Black majority. And the Voting Rights Act, according to the Gingell's requirements, requires Alabama to do that. So basically, the plaintiffs are saying Alabama must create a second Black majority district in the state. A lower district court agreed with them. The Supreme Court intervened and said, no, we're going to take this up, and kept the Republican district in place for the 2022 election while they decide the case. And it's now being decided today, or right now, the court will issue a decision. Alabama claims that the plaintiffs can only draw this district if they use race as a prime criterion. The court said you can't do that. So that's what's at issue. So on the left, we have the new district that the Republican legislature drew. So Alabama has 7 districts. All these other districts are Republican dominated and white dominated. District number 7 is a Black district. It looks very much like the map that they used prior to 2020. And this district number 7 went 67% for the Democrat in 2022, a few months ago, 33% for the Republican. All these other districts are majority white and majority Republican. But the plaintiffs are claiming that you can draw a second district with a Black majority. This is the so-called Black Belt across Alabama. All these districts are 60 to 70% Black, all of them across here, and the bordering ones are like 30 and 40%. This is the vote for president in 2016. All these counties across here voted for Hillary Clinton, plus Birmingham. All the rest of the state was for Trump, the Republican. So it's basically a Republican state, but here is the Black Belt. So the plaintiffs say you can create a second Black majority district here. So right here, the blue district, that would be another Black majority district. This would be a second one. So you'd have 2 districts, a majority Black, and 5 districts majority white. They've got different maps that get this result, but as you can see, this new district here goes across the so-called Black Belt in the South. So how is the court going to decide? Justices Kagan, Jackson, Sotomayor will vote to uphold Gingles and award Democrats a second congressional seat. Justices Gorsuch and Thomas have said that the Voting Rights Act applies to ballot access only and does not extend to districting. They would overrule Gingles and Allen. Justice Roberts will look for a compromise. Is one available? The Gingles test could go either way. You could award one more minority seat, or you could say that the plaintiffs are advocating a racial gerrymander and they're not allowed to do that. That leaves the decision to Alito, Coney Barrett, and Kavanaugh. I think it's quite likely that the court will decide that the Voting Rights Act applies to voting decisions only and does not extend to districting and electoral rules, which would really take the Voting Rights Act back to where it was in 1965. So there is a question: have we come to the end of the Civil Rights era, really kind of an end to the Voting Rights Act? Has it achieved its purpose? Blacks now vote in the South in equal proportions as whites. They get to elect legislators. The blacks are 13% of the total population in the United States. 13% of the House of Representatives are blacks. So has it achieved its goal? Have we kind of come to the end of the Civil Rights era because we've achieved the goals of the Civil Rights Act? You can look right here, you can see how the American population has changed. In 1960, we had 180 million people, 89% were white and 10% black. We had a polarized country, 90% white, 10% black. But as time has passed, the proportions have changed. The proportion of whites are now down to 62% after the 2020 census. Blacks are about 12%, but now it's 6% Asian and 19% Hispanic. So we now have a multiracial and a multi-ethnic country, no longer a black and white country. And does that mean we have to think differently about the whole civil rights era and the civil rights legislation that was passed at a time when we were divided only between blacks and whites? And so I'm going to end the presentation there and open it up for any questions.
I want to thank you all for listening. Thank you for your questions. And I want to thank Dr. Piereson for making it in spite of everything. And yes, Jim, we hope to have you back soon.
Yes.
Maybe something that has to do with political economy. So
excellent. Thank you, Danilo.
Okay.
Look forward to visiting again. Thanks,
everyone. Until soon.
Thank you.
Goodbye.